Hi, thank you for tuning into my YouTube channel. Today we're going to be talking about the STEM OPT problem that we get a lot of questions on. So basically, USCIS changed their STEM OPT website in about April of this year, and the date on the website actually says January, but we were only notified in April about this new STEM OPT policy change. And this policy change basically says that STEM OPT students cannot work off-site, and they have to work on the location of their employer who signs the I-983. So this obviously creates a huge problem for a lot of the IT STEM OPT applicants because they work in the client site. So we've been getting a lot of inquiries on this issue, so I kind of wanted to summarize it to see if there's any solutions. So basically, right now, USCIS is telling everyone, at least on their website, that they need to work at the location of the employer's site. And any third-party client's location placement will not be acceptable. The reasoning is that somehow ICE cannot have access or authority to visit the site, the work site where inspections will take place. And because they don't have the inspection, capability, then therefore they cannot establish the bona fide employer-employee relationship, and therefore, they cannot approve the STEM OPT application. This necessarily creates a lot of confusion, especially for those STEM OPT applicants who are already approved of their EADs to work on client site. Well, I mean, first of all, I would like to say that this type of enforcement and this interpretation of the rule is not supported by law. Although in the regulations, the STEM OPT regulations does require there to be a bona fide employer-employee relationship, and in a preamble of this document, ICE did say that they don't consider third-party client-side placement to be satisfactory of the employer-employee relationship because they cannot verify, that the training provided for the STEM OPT is done directly from the employer. But I think that fails to take into consideration the modern day work situation where, a lot of the IT professionals are working at the client side, and it is understandable that they do receive direct training from their employer via maybe like a manager on site or through modern technology where conference calls and video calls and other types of mechanisms can be used to provide training for these particular employees. Well, then that brings us to the question, what is the solution? What's a possible solution? We get this a lot because we're beginning to see RFEs for STEM OPT applicants who are being placed on the client's location, and USCI sends requests for evidence against their STEM OPT applications for bona fide employer-employee relationship. So far, we've seen about like 10 of them. It's not a lot. So this data is just beginning to be gathered. And so out of all the responses, we've gotten a couple approvals and a couple denials. So the application of this rule is definitely very inconsistent at this point. Well, the ones that are successful, have a few common traits. Well, first of all, the employer does have an on-site manager that can answer questions and provide training, and these trainings are specified very clearly, in the RFE response. So that's one common thing. All the ones that are approved, which is about 3 or 4 of them, they all have descriptive training of what the on-site manager will provide and how that coordinates with the employers from the headquarters. So just a lot of extra verbiage about how training is provided. And the second commonality of these approved cases is that the client provides a very detailed letter stating that they consent to ICE inspecting the location, and they give ICE authority to come and check out the place and to review documents and as related to the project so that they can determine that proper training has been taking place. So that's another commonality. So with those two, and then coupled with the legal argument that USCIS has no power to do this, to require requests for evidence for STEM OPT applicants who are placed on site because it doesn't conform with the regulations, and also the change in the change in their interpretation of the regulations as posted on the website is not sufficient because it doesn't go through the comment phase of like the public comment phase where people give their ideas as to what implications this rule change will take. Basically, it's just saying, hey, USCIS, you got to follow the law. The law doesn't say that you can't place employees on third-party sites. The law says that you could do that as long as the training is provided directly from the employer and there's a bona fide employee-employee relationship. So just a bunch of legal arguments coupled with the two factual evidence that the training is directly provided by the employer, on-site manager, ICE has authority to check out the facility. All these evidence together, we submit them, and an RFE response, and just pretty much hope for the best. Now, it has worked in some cases, but it has not worked for all. So that's where things are a little inconsistent. And STEM OPT is such a terrible, place to have this kind of attack, because if USCIS denies a STEM OPT, well, it's going to be really difficult to appeal it, and you can't refile because most likely it's already outside the 60-day post-graduation time window. So it really pigeonholes the applicants between a rock and a hard place, as the proverbial saying goes. So for all the new STEM OPT applicants who are going to be placed on third-party sites, well, what I would say, is that what I would tell the employer to do is to state that the employee will be working on site on the I-983. And then after the employee gets the card, then the EAD card, then the employer probably can update the DSO on the third-party placement sites, because that would be a material change generally when you change working location. I think that might allow the STEM OPT application to fly under the radar. That's what I think. I don't know for sure, but that's one way to do it, instead of presenting a STEM OPT application that is clearly, going to be placing the employee at the client side. So basically, you would say for the initial STEM OPT application that the employee is going to work on site at the employer's location. And after that's approved, then do an amendment or file a new I-983 to change the location to the client site. So that necessarily would delay the starting date of working at the client side, but that's somewhat unavoidable. So that's what I think can be done, for those of you who are going to file a STEM OPT application with a staffing agency or a temp agency that's going to place you at the client side. Well, maybe start with stating that you will be working at the employer's location, which is true. I mean, you could show up and look on their computer, get familiarized with your work, because I used to do agency work as well. I'm a Japanese document reviewer for certain legal agencies, and a lot of times we do the work on site for clients who are off-site. So in the beginning, we would sit there and review documents and look over their protocol, have conference calls, all taking place at the employer's location. So I think that's definitely something to start with for the first maybe couple months of the STEM OPT application to get the EAD card approved, then do the amendment on the I-983 to place it on the client side. That way, I think that USCIS would have little to do with the application because it's already been approved. So all it's doing is, reviewing the, all you're doing as an employee is to update the DSO with the new placement of the location. Now, I mean, if this solution doesn't work in the future, what will happen is that I think USCIS will consider any time that is placed with third-party sites to be out of status or not complying with OPT protocol, and therefore, if it exceeds that 120-day unemployment time, then the status is lost, and therefore, when the STEM OPT applicant applies for H-1Bs in the future, they might be required a consular process. I mean, it won't cause the H-1B to be denied, but, because the status didn't connect, since, they fell out of status, quote unquote, on during OPT time for working third-party sites, the H-1B petition will still be approved, but probably, the beneficiary will get an I-797B without an I-94 because the status didn't connect and therefore has to go outside the country, get H-1B stamping, and come back in to resume, to start H-1B status. That's what I think will happen. It won't cause the H-1B petition itself to be denied because it has nothing to do with this. But, failing to comply with STEM OPT regulations could cause USCIS to determine that STEM OPT status was not maintained, and therefore they cannot give a new I-94 when you try to apply for change of status to H-1B in the future. That's what I think will happen. So let me just make sure I go through the notes and that I've covered everything. I think that was pretty much all that I really wanted to say, but just in case, I know that I made some notes last night, so I just want to make sure that I covered everything. Okay, so timeline dated in January. Yes, it was very confusing. That we got notified in April, but the website says that it was updated in January. It's one of those really confusing moments, which I'm sure there are a lot in the USCIS history. And so just to kind of a recap, it is in its response to public comments on the 2016 STEM OPT rule. Department of Homeland Security cast doubts on whether consulting firms' arrangement in which a STEM OPT student is sent to a third-party site to perform services could satisfy the STEM OPT rules, as consulting companies may not be able to provide their STEM OPT student employees in the required in-person training at their clients' third-party locations. Well, this excuse seems very weak because, obviously if you have an on-site manager who's there to tell you, to train you on what to do, then that is in person and that is directly from the employer, so that problem seems to be solved pretty easily. So this same OPT rule seems to be a product of Trump. Most immigration lawyers agree that it's in response to Trump's Buy America, whatever, Do America policy, whatever that MAGA thing is. So this is probably a way to target just making generally the lives more difficult for international students. So what it says exactly, and what does offsite mean? So offsite, I get asked this question a lot. So offsite just means that you're not working at the location of the employer who signed the I-983. So sometimes people ask, hey, well, my employer has a subsidiary. Does that count as offsite? I mean, they're the same company. I would say, well, if they have a different federal employer identification number, and if one of them is E-Verify and the other one is not, then I think that's offsite. Anything that, like if I work for McDonald's, but I work in one of the McDonald's branches, then that's not offsite. But if I work for Apple, but then I get sent to Lenovo to fix computers, then that's offsite. So that's kind of an easy way to tell if something's offsite or not. Having a manager on site is a solution. Yes, I think that's definitely something that would be required in order to fix this issue, along with the client letter stating that access is granted to ICE for inspections. The keyword here seems to be access and in-person direct training. So those are the two keywords, and those keywords should be satisfied based on having a manager from the employer on site, and also have the client issue a very clear letter stating that access is granted to ICE for inspections. So yeah, other than that, other possible solutions, well, find an employer that doesn't place you off-site, or place you on-site for a couple months and then do the amendment with DSO. I think that would work. So there hasn't been a lot of information on this yet from different immigration lawyers, but this is definitely an issue that I think we're going to fight about with immigration for the months to come. Hopefully there will be some clarifications, but at this point, it kind of sucks for people who are applying for STEM OPT because they might get a nasty RFE, and even if we respond fully with everything we've got, there's no assurance that you'll get approved. So perhaps if you're applying for STEM OPT and the client and then the employer definitely wants to place you off-site and wants you to start immediately, I would say probably hold off a little bit, on the OPT application until at least a few weeks if you can. That way, maybe there's more clear guidance on the way. And also, once you file the STEM OPT application, your work eligibility is automatically extended for 180 days, so there shouldn't be a gap that you need to worry about. Well, I think that pretty much covers everything. Thank you for tuning in. And if you have any questions, feel free to contact me directly. I welcome questions, and I answered them pretty quickly, as many of you in the group should know. All right, well, thank you, and have a good day.